Hi, everyone. For those of you who don't know me, my name is Marie Lundi, and I am a real estate agent with eXp Realty. And thank you so very much, right, for being here today to cover this very important topic of estate planning with our special guest, attorney Thornton. And I realize that many of you are on your lunch break. So that being said, I want to be mindful of time. And so the first 40 minutes of this presentation will be devoted to the topic of estate planning, and the remaining 20 minutes of the hour will be devoted for Q&A. So that being said, once again, we are very, very fortunate to have attorney Thornton with us today. She is licensed in both New Jersey and New York, and her primary concentration is in the area of trust and estate planning, wealth transfer, asset protection, estate tax planning, and estate administration and guardianship. And so we are, once again, it's a pleasure having you with us, attorney Thornton, and I am going to turn it over to you to hear more about the topic of estate planning.
Thank you. Thank you so much. Marie, thank you so much for having me. When I spoke with Marie several months ago and we discussed it, I said, this is right up my alley, because with seminars, to be able to convey the information about estate planning, I think it's invaluable. So knowledge is power, knowledge is wealth. And so I am just hoping today to just make this as informational as possible. I think as Marie said, we're going to hold the questions and answers until the end. But with that, I'll just move forward and get started. I also found it interesting that Marie chose the topic of estate planning during the season of Valentine's, right? Because when we think about Valentine's Day, we're all thinking about love. And regardless of whether it's that significant other or the people in our lives that we love, and how do we take this day as a day of remembrance? And when I think about estate planning, overall, the concept of estate planning is love. It is being concerned about the folks that are in our lives, and realizing that unfortunately we all know we're not going to be here forever. We're trying to stay healthy and be here as long as we can, but we do know that life is finite. And so because of the folks in our lives that we care about and we love, having a good estate plan is one of the best ways that you can show your love for those people in your lives. So with that, I'm going to move forward with the theme of love and estate planning and how we can show our love through that way. So with that, Marie, if you'll indulge me, I do have a PowerPoint presentation that I'd like to share with the audience today.
Absolutely.
And I'm going to, let's see here, get that going. I think I did that wrong. Let's go again. Okay. All righty. So can everyone see that I am sharing my screen? I know a lot of folks are on mute, so if anyone is not seeing it, if you would let Marie know, and we'll see what adjustments we can make. Because short of that, I'm just going to move through the slides. Okay, so maybe you'll give a thumbs up.
I am seeing it.
Okay.
Sorry,
okay.
Yes.
Okay, so with that, I am Tomi Thornton. My full name, Thomasina Renee Thornton. Most folks know me as Tomi. And I am a trust and estates attorney. I've been practicing out of states of New York and New Jersey since the year 2000. I pretty much honed in on my practice being estate planning. That consists of preparing last will and testaments, power of attorneys, living wills, living trust, testamentary trust, and things of that sort. So I'm going to just go from one slide to the next, kind of talking about what the basics of estate planning are. So when we think about estate planning, those are our primary documents that we look at creating. Let's begin with a last will and testament, because most folks will call and say, hey, you know, I haven't done any estate planning and people are telling me that I need to create a will. In this country, we have found that still probably 67% of people pass away without a will. So let's talk about what a will actually is. A will is a legal document that tells the court when one passes away who you decide or elect to be in charge of all of the assets that pass through your estate, who your designated beneficiaries are, and how those beneficiaries are to receive the assets that are passing through your probate estate. Technically, that's just the definition of what a will is. Now, when we start talking about the different components of a will, let's talk about designated beneficiaries, because sometimes a will is not necessary, right? For the most part, as an estate planning attorney, we'll always say at least have a pour over will, but sometimes people create their testamentary intents in ways other than creating a last will and testament. So what do I mean by that? Some assets, if you own an asset that is an asset that is jointly owned, if you have a jointly owned asset, it means that when the first person passes away, the second person or the surviving joint owner of that account will automatically absorb the deceased owner's interest. So if you have a will, you don't need a will for that, because you have already told that financial entity who the designated beneficiary of those assets should be. If you have assets that are not jointly owned, meaning it's in your individual name, but you have named a designated beneficiary on that account, then again, that's an asset that you don't need a will for, because you've already told that institution, such as with a life insurance policy or on your retirement accounts or annuities or CDs, but you have already told that financial institution that when I pass away, here are the designated beneficiaries of whatever is left in that account upon one's demise. So a will, if you've got a jointly owned asset, you don't need a will for that particular asset. If you have an asset where you have a designated beneficiary, you do not need a will for that, because that's a contractual agreement between you and that financial institution. The other way that assets can pass without needing a will is through a living trust. And we're going to get to that shortly. Okay, so now for any asset that I've just discussed that's not jointly owned, there's no designated beneficiary, it is not a part of some living trust, everything else falls into your estate that will be passing through the surrogate's court. If one passes away without having those assets passing in those three categories, then you are deemed to have passed away intestate. So if you don't have a will, you have passed away intestate. And what that means is that the court is going to have to decide who will be in charge of your estate assets, who the rightful heirs at law of your estate are, and how those beneficiaries will receive those assets. Passing away intestate, for the most part, I don't recommend it, because it means that the court is going to have to decide who's going to be in charge of your estate. And because the court doesn't know your family members or your loved ones or your dear friends that you would have felt comfortable taking on that responsibility, the court's going to say, just in case that person or persons act inappropriately, we're going to require them to be bonded. So as you can see, the word bonding requirements are imposed on administrators. Bonding, I think, if you've ever had to be bonded, it's a dirty word because it's as though one has to take out an insurance policy in order to hold a position as the administrator for the decedent's estate. And again, it's done, however, for the protection of the beneficiaries, because the court doesn't know the administrator. And so they're taking a chance that that person is going to do a good job or not do a good job. And if they do not do a good job, in that particular instance, oops, Allie just said to me that this screen is looking small. Are you all able to see this clearly?
Yes, I am.
Let me see if I can open it a little larger. If
Hey,
I
Tom, you
can,
could click on the slideshow at the top.
okay,
It's one of the tab. It's
one of
the
the tabs.
one to
Oh, here's
there.
slideshow here.
Yeah, yes.
Okay,
And then from the current slide at the top.
okay. Here?
Nope.
No.
Upper left.
Okay. From beginning, a current
No,
slideshow.
from the current
Here?
slide. Yep.
Oh, okay. Is that better? Because it looks really
Yeah.
big to me.
Yeah.
Is that better for everyone to see it?
It is.
Okay. And will I be able to slide to go
Yep.
along?
Just go to the down arrow or next the
Oh, fabulous,
Yep.
fabulous. Everyone, I should have introduced Alyssa Davis. She is my legal assistant, and she is, I told her today she is my my office Valentine. Because she really helps to keep me on my toes. So if you ever call the office, she is a delight and very knowledgeable, and I'm very blessed to have her. So thank you so much for that, Allie. And
Thank you.
hopefully, again, everybody is seeing this very large because I'm now it's presenting much larger than it was.
Yes, for
So,
sure.
okay, so that being the case, so let's again talk about, I think I left off by saying that the will doesn't control everything. I think yes, I'd gotten past this. The next thing is that recognizing that if you pass away intestate without a will, the court's going to require you to be bonded. And in order to be bonded, number one, you've got to have good credit history. You're going to have to pay up front for that bond. So just like you do with your homeowner's insurance or car insurance, you have to pay a premium. The better your credit, the less your premium. And again, if your credit is not necessarily up to par, then you will not be able to be bonded, which means that the court will have to find someone else to be the administrator of the decedent's estate. That someone else may not even be a family member. It may wind up being an attorney. And so having a bond and having language in it that creates your executor is extremely valuable. All right, let's see. Okay, good. I see how it's moving. All right. So again, creating that executor is what are some of the responsibilities of what your executor has to do? The executor has to collect all the assets that don't fall into those three categories. It's not jointly owned. There's no designated beneficiary. It's not under trust. Everything else, it is their responsibility to collect it all. They have to pay your taxes. They've got to take care of paying all of your expenses, funeral bills, administration costs, personal loans, whatever the liabilities that you owe at the time of your death, your executor is obligated to satisfy those expenses before they can make any distributions to your beneficiaries. They're inventorying, they're eventually decide there's property, they may have to sell the property, they may have to transfer it. So it is a big responsibility to be an executor. Your last will and testament will also allow you to name guardians for your minor children, which is also extremely important because if you do not have a will and let's say you don't have a spouse or you believe that your spouse or the child's biological parent is not the best person to have physical custody, this is your opportunity to decide in your will who should be the guardian of your minor children. And many times the courts will look to obviously the best interest of the child, but they will look for some guidance that can be incorporated in your last will and testament. Okay. Creating a last will and testament, particularly let's talk about children. If you have children who are under the age of 18, and if you have named your child as a beneficiary, and this is regardless of whether you've named them as a beneficiary in your will or you've made them a beneficiary of your insurance policies or on your account, on any financial accounts. If they're under the age of 18, their monies will have to be held with the surrogate's court. It's going to be held in an escrow account. Escrow accounts generally are only going to be based on money market rates. So you could wind up having the court hold the monies for minor children at money market rates, which, at one point was less than 1%, until the child reaches the age of 18. And when that child reaches the age of 18, the court has no option but to release those funds to that child. And unfortunately, all 18-year-olds are not created equal. So if we are looking to make sure that children receive an inheritance that they are going to be able to handle properly, sometimes creating maybe a testamentary trust in your last will and testament might be a useful vehicle. And again, this doesn't just apply to children who are minors. You may sometimes have kids that we love all our kids, but sometimes they make decisions, even as young adults, even as little older adults, that we might not feel is appropriate. So again, creating a testamentary trust means that their inheritance is going to be looked after by a trustee that you feel is going to make good decisions on their behalf. And then maybe you can set it up where the kids start receiving a part of the corpus when they reach certain ages. So examples, children, the monies that are left for children can be used for their health, education, maintenance, welfare, but then maybe indicating once they reach the age of 22, they'll get 20% of what's in their trust fund. When they reach 26, they'll get another 20%. When they reach 30, they'll get another, and so on and so forth. So you can understand this is kind of helping them to grow into a little bit of maturity, learn life's lessons, so that that inheritance can be beneficial to them. Also, if you have beneficiaries, whether they're children or spouses or our family members who may have some form of a disability, leaving assets to them could result in them losing their eligibility for governmental assistance. So sometimes people will create what we call special needs trust, which is again a way of giving a loved one an inheritance without them losing their government status for either Medicaid or DDD or something of that sort. So a special needs trust can also come in handy. One other reason that you want to think about having a last will and testament is, again, remember I said that if you pass away without a will, you pass away intestate, that means that the court's going to decide who the beneficiaries are. And the beneficiaries under an administration are actually called heirs at law. Heirs at law are technically your next of kin. Sometimes that's a good thing. Sometimes it may not be. Let's say you don't have children and your next of kin would be your siblings. Maybe you want to leave monies to your nieces and your nephews, or to a dear friend, or to a charity, or to other individuals that are not considered next of kin, but they are dear to your heart. The court won't be able to help you because they're going to look to see whoever the next of kin is. And when I say siblings, I don't mean just whole siblings. I mean half siblings. I mean, they have to go a distance to try to figure out who is a half sibling in order to be able to give them an inheritance, but that is going to be required by the court. So again, if you want to leave assets to individuals who are not necessarily next of kin, then you need a last will and testament, because you'll be able to designate specifically who your beneficiaries of your estate should be. So we kind of talked about trust, and I think I didn't pass there. Now, one other thing for you to be aware of is that we used to create trust where we did a lot more tax planning. We're not seeing that as much anymore. The reason for that is because in this country, the federal estate tax exemption is currently $13.99 million for 2025. So what does that mean? That means if you own less than basically $13.99 million, you do not have a federal estate tax. If you are married, you and your spouse can double that amount. As long as you're both U.S. citizens, it's going to be 13.99 times 2, so almost $28 million. So again, if you own less as a couple than $28 million, you don't have a federal estate tax. If you're an individual and you own less than close to 14 million, you do not have a federal estate tax liability. If you have more than that, you be sure to give me a call and we will talk about that. But at any rate, just kidding. What New Jersey does have is an inheritance tax. Now, New Jersey also no longer has a New Jersey estate tax. We used to, but as of January 1st, 2018, New Jersey does not have an estate tax. What New Jersey does have is an inheritance tax. So what does that mean? That means that if you create a will or your beneficiaries are Class A beneficiaries, you don't have to worry about this. I'm not talking to you right now. So if you're leaving assets to your spouses, to partners, parents, grandparents, grandchildren, children, no tax, no inheritance tax. However, once we start to go beyond that part of our loving tree and we start moving to our siblings, there will be a New Jersey inheritance tax. Our siblings are given a $25,000 exemption. So on the first $25,000, no tax to any of our siblings or to any of our children's spouses, $25,000 exemption. But once you go beyond $25,000, then their inheritance is going to be somewhere between 11 and 16% of whatever they have received by way of their inheritance. Class D is going to be anyone outside of Class A and C. So now we're talking about nieces, nephews, cousins, good friends, any of those folks who fall into Class D, you get a tax regardless of how much you receive, somewhere between 15 and 16%. And then finally, under Class E, those are going to be our charitable organizations. There is absolutely no tax. So in the state of New Jersey, the takeaway is, yes, we do have a New Jersey inheritance tax, and that tax is going to be due, has to be paid to the New Jersey Division of Taxation no later than 8 months. I think it's 8 months after the date of death. Okay. All right, moving on. Now let's talk about, because sometimes folks will say, I need a trust, right? So let's talk about first, what is a trust? A trust is a taxable entity that holds assets for the benefit of a third party. Okay. Can everyone see this? I know this is a lot going on, but when I think about a trust, I think about this pyramid or this triangle that's directly in front of you. A trust is a taxable entity that you can call anything you want to. You can call it, as you can see, John Doe and Charlotte Doe Trust. Or if you want to give some anonymity to it, you can call it the Red Jelly Bean Trust. Call it anything that you want to call it. You can create this trust, you as the grantor. So when I say you creating it, you're referred to as the grantor or the settlor. You are the person who is in charge. You have made all these decisions around. You have decided whether you're going to create this trust during your lifetime or you're going to create this trust in your last will and testament. You're going to decide, is it going to be revocable or irrevocable? If it is revocable, it means you can make changes at any given time. You can put your house, retitle it, put it into the trust. If you want to next year sell that, you can sell it. You can change up any of the beneficiaries. You can decide who the trustees will be. You can decide when those beneficiaries are going to receive parts of what's included in your trust, what criteria they have to meet. Is it going to be a needs trust? Will it be a special needs trust? You can decide anything that you so choose. I think the biggest thing you need to decide is, why do I need a trust? And the reason that it's confusing when folks call is because usually they've seen something, they've read something, and they may say, oh, which is a personality. I like Susie Orman, right? And Susie Orman says, oh, hey, you need to have a trust. Susie Orman lives or does a lot of work out in California. The problem with the United States is that every state is different. All of our laws are different. The only thing that we have that is united would be our federal laws, but our state laws, city laws, county laws, even down to the surrogates court, how the surrogates court in Bergen County works different than they do in Middlesex County versus what Essex County does. So there is nothing united about our laws. And so therefore, when people pass away in California, it may be more advantageous to create a trust because California will charge filing fees or probate fees on what you own in your individual name at the time of your death. So that's why people in, let's say, California or maybe even Pennsylvania are more inclined to put things into a trust, because if it's not in their individual name, they don't have to pay a probate fee when they pass away. New Jersey has a flat fee. You can pass away in New Jersey regardless of what county you live in. It's a flat fee of basically about $145. They don't care whether you have $100,000 or $100 million. It's a flat fee to file, to have your will placed into probate. So again, recognizing trust, depending on what you are trying to accomplish, that will help you decide, do you need to create a trust during your lifetime, or would it suffice to wait until you've passed away and then you're creating this testamentary trust so that those beneficiaries have someone who will help them address their inheritance. Okay, so that's pretty much the nutshell on trust. Now, outside of that, we have two other documents that I think are, tell you what, I'm going to skip because I think there's a better way. I was looking at this earlier today, and I'm going to move this around and we're going to come back to it. So a couple of things that I want you to think about when it comes to a will, and I think Marie may have shared this with you, but when you start looking at creating a last will and testament, if you fill out a form like this, this is going to really help you to start putting some basic information together. You're considered the testator. You're the person who's going to make your plan by creating your last will and testament, your power of attorney, your advance directive. So that's going to be your name. You're going to decide on who your executor is. That's the person who is in charge. Always have an alternate, because we just never know what could happen. Your executor might wind up being younger than you, but God forbid, life throw us some lemonades, some lemons. You've got an executor who may not be able to serve in that position. And if you have named an executor in your will and that person is unable to serve, then the court has no choice but to go back and look at your fiduciary as though they were an administrator, decide on who the administrator is going to be, and require them to be bonded because they don't know them. So again, an executor and an alternate, always having at least two fiduciaries almost in any capacity is just well worth it. Deciding on who your funeral representative has to be. These folks don't have to be the same, right? Sometimes you may say, my executor may handle money better. They may do it on a much longer term basis. Whereas the funeral representative, that might be my sister because she knows how I want to look. If God forbid, when I close my eyes, I better be looking a certain way. And I want her to be that person who's going to decide how I'm going to appear, what flowers are going to be, what information. Maybe I've already created my obituary, making sure that that information is honored, what type of ceremony. So again, having a funeral representative, a person that you know, that you trust, will make sure that your funeral arrangements are carried out. I would put that information in my last will and testament and let them know, and we'll share why in a minute. But for the most part, you're indicating your executor in your will, your funeral representative, and alternative individuals. Specific bequests. This is important because in your will, you may say, I want everything equally divided between my kids, but I also want to make sure that I have left my church $2,500. I want to leave my sister, Deborah, I want to give her at least $10,000. The only thing I want you to recognize with specific bequests is that they're paid first. So after your executor collects your assets, they pay out your funeral, they pay out all of your expenses, and now they got what's left over in the pot. And let's say they've got $284,000 left over in the pot. Under a specific bequest, Deborah gets the first $10,000 out of that pot. Your church, your alma mater, your fraternity, sorority, they get the first $2,500. And then whatever is left goes into your residuary estate, which is now divided as 80% to my son Henry and 30% you understand what I'm saying? Whatever's left over goes to your residuary beneficiaries. You also want to indicate whether you have alternate beneficiaries. You want to indicate whether those beneficiaries, if God forbid they predeceased you and they have children, do you want those children to receive what that deceased residuary beneficiary would have received? So these are things that you can indicate in your last will and testament. You also want to, if you have minor children, name your guardian. If you have a testamentary trust, decide if it's going to be a pot trust, meaning all the money's together, or separate trust for each separate child. You'll indicate whether the monies can be used for their ascertainable standard or whether they're going to get distributions at certain ages. You're going to decide on who the trustees are. Again, primary, successor, final legatees. I always tell folks, why not, right? It's almost a time to kind of be fun, right? What if you were on a ship together, and I've got three adult daughters, no grandkids yet, hopefully some point in time, but right now it's just, those are the most cherished folks, you know, in my life, my kids. So if God forbid we're all on vacation together and we do vacation together and the unexpected, unimaginable happens, then what would I want to do left? What's left? You know, who do I want it to go to? So this is the chance for you to say, hey, you know, I'm giving a certain percentage to the United Negro College Fund. I'm giving some to American Red Cross. I'm giving some to my siblings. I'm giving some to my class of 19. I'll never tell you. So it's that kind of thing where you get to really say, in the event those that are most dear to me, those that I love are not here to inherit, rather than the court deciding whoever my next of kin is, I can tell the court what I want to happen to those monies. Okay, so that's pretty much it for the power, for the last will and testament. Power of attorney. Now, the difference with the last will and testament, I should have said that up front. This wonderful instrument is not going to be of any use to you while you are living. Nothing happens with the will during your lifetime. However, during one's lifetime, sometimes we may not have a tragic accident where we've passed away, but we may have a medical circumstance in our lives where we are maybe temporarily or unable to handle our legal and financial affairs. A power of attorney document is a valuable instrument because it allows another person that we trust the ability to have access to our monies, right? Access to make sure that our mortgage gets paid and a car note gets paid and the homeowner's insurance and any of those things can continue to operate until we get back on our feet. So a power of attorney is an instrument that you use during your lifetime, giving another person the ability to help you until you're able to effectively make decisions on your own accord. It can be springing or it can be durable. Springing means that they need to provide documentation to your financial advisors as to why they're there, not you. Durable means the minute you give it to them, they're able to go down to Chase Bank, cash a check, make a deposit, do whatever they need to do on your behalf. A power of attorney is only valid during your lifetime. So when you pass away, a power of attorney is null and void. And sometimes it just breaks my heart that people will come into my office and they present this power of attorney and they're like, I've been down to the courthouse. I lost my aunt. I've done things for her for the last 15 years. I've gone down to the courthouse. I showed them the power of attorney. I'm trying to take care. She just passed away. And they've turned me away and said that this power of attorney is no good. Surely, Tomi, that cannot be true. Right. And unfortunately, I have to break the news to them. Yeah, that is true. Unfortunately, when your aunt passed away, that power of attorney is automatically revoked. So that is the reason why you need to, again, have that last will and testament in place. The next document that we can only use during our lifetime is what we call a living will. Sometimes they call it a healthcare directive, an advance directive, different terms, healthcare proxy. This is the document that tells your medical provider the types of treatment you wish to have or the types of treatment you wish not to have in the event of a catastrophic illness. So again, we want to name a healthcare representative because if we can't advocate for ourselves and understand what is going on in regards to making medical decisions, we want a healthcare representative there to be able to talk to the doctors, to hire more doctors to move us from one hospital to the next if they need to. So a healthcare representative and an alternate is very important to have. This living will also gives us the ability, again, to say whether we want to be on life support or not. And it's a tough decision. Sometimes folks will say, I don't know. I'm going to leave it up to my healthcare representative, particularly under COVID. We saw people on ventilators for months. I've never seen that before, unless you were watching One Life to Live, it might be on a ventilator 6 months, and it's a miracle. That generally doesn't happen. But with COVID, we did see some miracles. We saw people on ventilators for extensive periods, and those who were blessed were able to come off of that ventilator machine, which is a form of life support. So this has become a little bit more of a document that takes a little bit more thought in terms of making those types of decisions, but it is very, very valuable. And it's particularly valuable when you don't maybe have a spouse and you have extended family and those family members don't agree. Because the worst thing that can happen is you've got multiple people heading over to the hospital. They don't agree. And now you've got doctors and medical staff at a crossroads. And when people get at a crossroads, you know what they do? They shut it down. They say stop. They say go over to the courthouse and let the judge tell us who is going to be in charge, and then come back. And whenever you have to go to the courthouse, what happens? You got to hire people like me, which I would love to serve. But what does that mean? Money, time. So again, creating these types of documents are just invaluable. So let's go back to one other thing, and then we're going to go into a little bit, and I'm sorry I'm moving around, but as I tell my story, I'm hoping that you all are following me. Let's come back again to this guardianship, and this is the reason why having a power of attorney and a living will is so important. Because if you don't have those documents, when I say you got to go over to the courthouse, this is what we're going for. We're going for a guardianship. And guardianship, unlike a power of attorney or a living will that you could just have drafted by calling someone like me to put those documents together for you, this is expensive. Now, this is expensive because now you got to do an order to show cause. You've got to have a verified complaint. You have to have a hearing before a judge. The judge, not only will you more than likely have to hire an attorney, the court will also have to hire an attorney on behalf of your loved one, because they don't know you and they want to protect the loved one. All of these costs are coming from you. They're going to have to come from your bank account. So you're going to pay for all of that, the court time, the attorney's fees. You're going to have 2 doctors declare you to be incapacitated. There are going to be hearings. And still there's going to be bonding every year because the judge does not know who the person is that they eventually will name as your guardian. So again, this is a process. Sometimes it is just necessary. But if one during your lifetime can make the decision, I'm going to decide who's going to be the person who's going to help me. I'm going to decide on those medical decisions or on those financial decisions. I don't want the court to get involved because this process is timely and it takes the power out of my hands. Okay. So that is kind of power of attorneys and living wills in a nutshell. And I think we may be bringing this to conclusion. Oh, I know it. Sometimes people will say to me, how do I go about figuring out who is going to be my fiduciary? The folks have this saying when they play, we just watched the Super Bowl, right? So you got your A team, right? And you got your B team, the bench, right? So let's go Eagles. But the reason that I'm saying that is because sometimes you're fortunate to have what they call a deep bench, right? Meaning even people on the B team are good. A team is definitely good, but B team is good. And then other times we can barely put an A team together, right? And that's just the way it is. Sometimes we have small families and or a small circle, and it becomes difficult to decide. And that I think makes folks kind of not move forward because they're just not sure who to name when it comes to those fiduciaries. So something to know, whoever you name has to be at least 18 years old. They need to be at least competent. These might be basic, but these are warning signs. If you know that the rumor in the family is that such and such might have a substance abuse, right? That's what they say. I've never seen, he never was high in front of me. But if that's what you are hearing, as the kids say on the street, that's probably not the person that you want to name as your agent, especially on a power of attorney, because they're going to have access to your accounts. So you want to name somebody who, you know, it doesn't have poor judgment, is not known for making decisions, might have a sweetheart, bless her heart, but they just don't always make those types of decisions on their own accord. So you know they may not make it on yours. So these are warning signs to look for, okay? These are some of the things that I like to look for. I like to look for someone, if you have your own home and, you know, I can come to your house and have a cup of coffee and everything on the surface at least looks good, that at least is something for you to consider. Just trying to be observant, because at the end of the day, your fiduciaries, I think the main three components is that they should be trustworthy. And that's the reason that the word is the word trust, I think, is in the word trustee. They need to be a trustworthy person, have integrity, have honor. They also need to be resourceful. So resourceful doesn't mean, oh, I need somebody, oh, they must have a master's, though I mean, it's not a bad thing, but they don't have to have graduated from Harvard or Howard, but they need to be resourceful. So if they need to know there's something in accounting, I don't know how to file these tax returns, they need to know how to pick up the phone and reach out to someone and call. If they know, well, we got to get this house sold, they need to be able to call Marie because they know she's a great real estate agent, right? They need to be resourceful and know the folks that they can call to get the information that they need to be able to handle your affairs. And then the last thing is that they need to have some time, right? So if you have someone who is on the surface a fabulous person and hits those first two, but they have 3 businesses on the side and they got podcasts and they travel back and forth every time you turn around, they're on Facebook. And I'm only saying this because I've had these kinds of experiences with people. They may not have the time, because sometimes when you are asked to serve as a fiduciary, you have to realize, wait a minute, I already have my own household. There are people on here right now who's saying, okay, I'm gonna have to get back to work in a minute, Thomas. So we all have our busy lives. So again, you need to name someone that you trust, someone who's resourceful, and they still need to have the time because they have to manage their own household. And now they need to help you until you're back on your feet. Okay. So those are some of the things that one should consider when we're trying to decide who's going to be our executor. We have a trust. Who's a trustee? Who are the agents? Who are those agents under the power of attorney? Who's the healthcare representatives and things of that sort? And so with that, I'm just kind of bringing this to the conclusion. Again, in the spirit of Valentine's Day, in the spirit of love, creating an estate plan because we love our children and our significant others and our churches. And we love the fact that we are trying to build up wealth. And we love the fact that once we take care of our estate plan, we now at least have that feeling of, you know, I handle my business. I got it going. I'm all right. So with that, I thank you all for listening.
Wow.
Marie?
Thank you so very much, Attorney Thornton. This was amazing information. I just want to hear from you guys. You know, we're not seeing your faces, but drop a heart, clap, whatever it takes. Wasn't that amazing information from Attorney Thornton? And so I know I'm going to get those phone calls, Tomi. I know I am. You were amazing. Thank you so very much for this information. I want to hear from you also before we move forward on to questions. What is the best way for folks to reach out to you if they have further question or want a consultation?
Okay. And so I put on the screen, as I said, I'm New York and New Jersey. Can everyone see that final screen? I would suggest calling. If you're in New York, you can call the 212 number. If you're in New Jersey, call that 973-275-5476. And ask for Allie. And I do give a 30-minute complimentary consultation. So if you just want to at least kind of go through maybe some specifics, feel free to give me a call and I'd love to talk to you. So again, 973-275-5476. And the email is trt.estatelaw@gmail.com. So my initials, trt.estatelaw@gmail.com.
And Tommy, do you prefer email or a phone call? Which is better for you?
Whichever works better for you all. Allie, fortunately, she's on the line here. So just call, ask for Allie, and then she'll get you on the calendar. We'll also send you out some information in regards to the different documents for estate planning. So that'll also provide just some more information. And if you get a chance, try to read that over. And then that way you can make that meeting as substantive as possible.
Sounds fantastic. So thanks again. I just want to open up the floor to a couple of questions. If you have any questions right now, feel free to unmute yourself so that you could ask Attorney Thornton the questions directly. And I see that everyone is kind of shy, so I'm just going to get started.
Hello, do you hear me?
Tommy, just wanted to know if someone currently has a will, okay, are you also able to help them maybe make some adjustments, review it, and make some suggestions there?
That's a good question. So if you have a last will and testament, we always tell folks, look at your will every year. Most people don't do that, but we encourage you to do it because you may have some altering life incidences that need to have revisions done. If you want a small revision done in your last will and testament, there's really no need to do the entire will over. You can do what's called a codicil. It's CODICIL, which is just a small revision, maybe to Article 2. So I'm changing up instead of Deborah getting 10%, she's gonna get 20%. Or I decided I'm going to give my little red Corvette to Susie. So we can always make small little adjustments by way of a codicil. Now, if you need to make a big change, or you haven't changed that will in 15 years or so, then maybe it is time to kind of revise it. And for the most part, I don't review wills other than in the consultation. So if you need a consultation that's longer than the half an hour, then you can pay the consult fee and we'll review the will at the same time together. So that's generally how that's handled.
Fantastic. Thank you for that. Any other questions? Feel free to unmute yourself.
Yes. Do you hear me? This is Rodney Abrams.
Hi, Rodney.
Hey, Tommy, how you doing?
I'm well. How are you?
I'm doing well. A question for you, a two-part question. Hey, I have a will from the Army from about 10 years ago. Can you do it like the codicil for something like that, even though the Army prepared it?
Yes, absolutely. Absolutely.
Okay, great. And then my second question concerns the difference, because I'm debating if I should get a trust or not. If everything you said, if you live in New Jersey and you don't have no more, and if you don't have more than $13 million and you have adult kids, where's the wealth building thing by having a trust? I don't understand why would I get a trust. And if I have like brokerage accounts with beneficiaries already on the accounts, because those won't typically go into a trust from my research. What would be the benefit of the will? What would be the why you think someone would want one over? I'm finished.
Yeah, and that's the reason. So let's go to your saying of what you're saying. That's why when folks come to me and say, "Oh, I'm coming because I need a trust," that's going to be my first question to you: is what are you trying to accomplish? Because if you've got 3 adult kids and everybody is mature, they're making good decisions for themselves, you know that God forbid if you transition next year and they are the recipients of those assets, they're going to handle those assets wisely. You don't necessarily need someone to oversee the monies for them. So again, it's trying to figure out, why do you need this trust? New Jersey does not have an estate tax. So we're not creating these marital elective share trusts that we used to do. We used to do something called the credit shelters or the bypass because our exemption was much smaller. It used to be 675,000, and then it slowly crept up to 2 million. But as meaning that if you owned more than $2 million, which is not difficult to do in New Jersey because real estate alone, you know, you could easily buy a house for 800,000. So when we had that smaller exemption, we used to do more credit shelter trust. But again, as of January 1st, 2018, no New Jersey estate tax. The federal estate tax is 13.9 million. So people aren't concerned about taxes like we used to be. Now, that doesn't mean the inheritance tax is no longer there. But again, to answer your question, if you have beneficiaries who are more than capable of handling their own affairs, they don't have any kind of special needs, they don't need assistance, an outright distribution may suffice, and there's no reason to have a trust. I personally believe in that New Jersey's probate process is fairly straightforward, and more straightforward than even New York. And we're right, you know, we're just divided by the Hudson. New York is much more paper intense. New York requires more in terms of people approving the will than New Jersey. New Jersey says, hey, you got a good looking will here. It's been signed by the testator. There are 2 witnesses. It's been notarized. It doesn't appear tampered with, meaning somebody wasn't scratching on it, or pages aren't missing, or staplers are out of it. If it looks like a legitimate will, it's going to be admitted. And you don't need to tell anybody what's in it, or they have to take a look at it before. So every state is different. So depending on where you live, I don't always tell folks right off the top, oh yeah, you should definitely have a trust. It depends on what you're trying to accomplish. Okay.
Very good question.
Thank you. Thank you. Okay.
Any other questions? Feel free to unmute yourself.
Okay.
So we have a quiet bunch today, and
I have,
go ahead.
I'm sorry, I have a quick question.
Yes.
If you have a trust and will and everything set up in Texas, but you own property also in New Jersey, is it necessary to have separate documents, or can it all be addressed in one?
That is a very good question, and I'm so glad. And that actually is going to be something that I'm going to incorporate into my slide now that you say that, because here is the situation. Remember I said there's nothing united about our states?
Yes.
New Jersey. So let's say you're a resident of New Jersey, but you own property in Houston. And now that property is not in a trust. Now you pass away. You're a resident of New Jersey. New Jersey can't tell Texas what to do with property. So you have to go through ancillary proceedings. They call them exemplified ancillary proceedings in the state of Texas in order to deal with that property. That is one of the reasons why people will, if you own property outside of the state of New Jersey, take that property and put it into a trust. Because as I said from the beginning, assets that are in a trust don't go through probate. So you don't need the state court, the surrogate's court in Texas to get involved. You don't need New Jersey to get involved because it is in a living trust. That is one way to avoid probate for those assets that are owned in the trust. So again, the Texas property, if you placed it into the Shea Asset Trust, then that property doesn't require probate. And that would be one of the benefits of having a living trust. Now, recognizing that with the living trust, you put it into this trust, you have to retitle it. So it's no longer going to be in your name. It's going to be in the name of the Shea Asset Trust, right? It's a taxable entity, which means you have to file a tax return on it every year, because that's what a trust is, a taxable entity that holds assets for the benefit of a third party. So there are going to be some requirements of what you need to do. You'll need to decide if it's going to be revocable or it's going to be irrevocable, but it will avoid the need for you to have to go through any kind of probate proceedings. And I do think that that's one of the advantages of having a living trust, because how many hoops is Texas going to make me jump through in order to be able to, when you pass away, in order to be able to deal with that deal with that property. One other reason that people do those types of living trust as well is because, let's say, well, I can't think of Texas, but let's say you had property in Martha's Vineyard, right? So a lot of folks have property in Martha's Vineyard that they've had for years, right? And it means something, or it's in Hilton Head, South Carolina. It's been in the family, or it's land down in Mississippi or in North Carolina. And when they pass away, they're like, my great-grandparents own this property. I do not want this property sold. So even when I pass away, I want to make sure that this property stays in this family. That's one way of placing the property into this trust, because when you set up the trust, you're making all the rules. So you decide, no, this property cannot be sold. And maybe the rental income is going to be used for the maintenance. And if there's a shortfall, I'm also going to leave a small little insurance policy that's the beneficiary, the trust is the beneficiary of, to kind of help with the maintenance costs, because I want this property to stay in the family long after I'm already in the ground. It's maintaining, that's one thing that a trust will allow you to do, is to maintain control even after you've passed away. Did that answer?
Got it. So if I'm understanding correctly, as long as it's in the trust, I don't have to worry about separate documents for each state in which I own property.
That's exactly right. You do not have to go through exemplified ancillary proceedings. You do not, because it's in the trust, because the trust owns it, because it's not in your individual name. So you do not have to get the surrogates court involved in Harris County.
Perfect. Thank you.
You're welcome.
Fantastic, Shaq. Very good question. And so, to be mindful of everyone's time, including Tomi. Tomi, thank you so very much for this information.
You're welcome.
I've learned a great deal. I'm sure everybody has as well. And this is very important information. Once again, in the spirit of Valentine's Day, thinking about your loved ones. This is so timely. So we thank you, Tomi. Also, wanted to point out that this webinar is recorded, okay? So if you've missed any part of the webinar, or if you just want to go through it again, please text me or email me, and I'm more than happy to send you the recording of this presentation. Feel free to share it. Is that okay, Tomi?
Absolutely, absolutely.
Right. Feel free to share it with people within your community, your church. This is important information to make widely available to everyone that we love. Okay. Any last words, Tomi, for the group?
Just thank you all for your attention today. As I said, I hope everyone got something out of it. And estate planning is love. And so to everyone, happy Valentine's Day.
Fantastic. Thanks again, Tomi. Thank you guys for being here. Happy Valentine's Day to you guys as well. Bye-bye.